Welcome, misters and sisters. Nice to see you again. I'm the Lincoln Lawyer. Welcome back to the show of the shit you really need to know and want to know. Today, we're going to get into non-competes. Non-compete. We're not going to discuss any other provisions in employment agreements other than non-competes. Non-circumvention, non-solicitation, non-disclosure, confidentiality, none of that. Maybe another video. We'll see. I haven't decided yet. Non-compete only. Now, next thing. Non-competes do not apply to independent contractors. You cannot prescribe how an independent 1099 contractor makes a living. It is just totally unfair. So that the definition of a contractor, independent contractor, is they work whenever they want for whomever they want. That's it. If you try to limit their ability to earn a living, to work for any employer at any time and do their own job as they see fit, then that provision will be null and void, or potentially they may be deemed an employee, and then you'll be liable for various employment benefits, or the employer will be liable. Okay, so just something to get out of the way. W-2s only, not 1099s. Now, next thing, the law in general is loath to enforce non-competes. Okay, something you need to understand, that in the Constitution we are granted the rights to life, liberty, and pursuit of happiness. Inherent in those rights is the right to earn a living, to work anywhere one wants to support oneself and their family. Okay, so restricting that right is generally anathema in the legal system. Now, counterbalancing that right is the right of a business to protect itself. A business owner invests money in its business, in its operations, hires employees, it hires someone, it teaches them, they train them, teach them everything about the business, invest in the employee, cost money, then the employee leaves, opens a competing business, and then the original employer suffers, or they may be completely out of business. Who knows? It happens. So the rights of the business need to be weighed against the rights of the employee. And this is why non-competes are narrowly construed, generally speaking. They have to be narrowly focused, narrowly construed, and reasonable in scope. Okay, moving on. So some professions are more likely to have their non-competes enforced than others. So the higher the skill, the more specialized a profession, the more likely the non-compete will be enforced. Also, the higher the salary, the more likely the employer is going to go after that former employee for violation of the non-compete. So professions such as medical, physician, even specialized nurses, so legal, okay, definitely. Let's say mechanic, a specialized mechanic, who's one of the few people who can work on certain cars, maybe a boat mechanic, maybe an airplane mechanic. Maybe a welder of some kind, a specialized welder who's got amazing welding skills. They're hard to find, they're hard to replace. So the harder it is to find a replacement and train them, the more likely a non-compete will be enforced. Other professions like retail, phone call sales, cold calling, stuff like that, restaurant operations, administrative, clerical stuff, it's very unlikely to be enforced completely or extremely limited in the enforcement. Okay, so a waiter should have the right, unrestricted right, to quit their job today and go next door and work there the next night without any kind of fear of limitations, without any contractual binding restrictions. Okay, so that's pretty much how it would likely work. Okay, now another item to think about is that an employer will rarely attempt to enforce their non-compete. This is very rarely done, okay? First of all, let's say you work for someone, you quit, and you go to work for a competitor in violation of the restrictions in the non-compete. So how is the former employer going to know? I mean, what, are they tracking you? Are they following you online? Are they following you around? They have investigators. They're not going to find out anytime soon. They might see you eventually there. They might hear about it. They might see it online. Who knows? Maybe 3, 6 months, a year later. Then they have to hire a lawyer. They have to pay them a deposit. They have to file a claim for breach of contract. They have to serve you. They have to litigate it. I mean, who's going to go through all that just to enforce an agreement that's almost over anyway? And is a court going to actually order you to quit your job and go work elsewhere in a different location, that's not in violation of your non-compete. Now, that's bullshit. That'll never happen. It doesn't happen. They're going to say it's too late. You waived your right to enforce your non-compete. Sorry, you fucked up. So you wasted all your money trying to enforce it. All right? So it's highly unlikely to be enforced. There are exceptions. We're going to talk about that at the end. So exceptions with larger employers with lots of money, institutions, etc., stuff like that. Okay, so now a couple of things you are very likely to see in your non-compete. Okay, a time limitation and a location limitation. All right, you cannot have a non-compete that's unlimited in location and time. It's permanent. You're permanently banned from working in this industry forever in the world. That's bullshit. That's null and void right off the bat. Somebody tries to do that to you, forget it. It's null and void. You can sign it because it'll never be enforced. So you don't have to even negotiate that. That's bullshit. Okay, so location. The reasonableness of a location restriction depends on where the employer is located. So it depends on if it's rural, if it's urban, suburban, whatever. If the less population density, then the larger the location restriction will be permitted. So if you're out in the country, a restriction of 5 miles, 10 miles, you might go through maybe 3, 4, 5 farms in that distance. You know, you have a specialized, let's say, a farmhand specialist, a breeder of some kind, a pig breeder, cow breeder, pumpkin breeder, whatever, and you don't want them to work for a competing farmer. You can limit, 5 miles, 10 miles, okay, because, you got whatever competitions going on. So that'll probably be reasonable. Now, in a city where you got 500 people on a block, that's a no-go. That's not going to happen. You got competing businesses a couple of blocks you got a competing business. You can't limit a hairstylist from working for another hairstylist within the city of Dallas, for example. Okay, so city, county limitations, that kind of thing, borders will be more permissible in rural, suburban areas. In the city, it's more likely to be distance, but you can use distance anywhere, so that's fine. But generally, in the city, it's going to be half a mile to a mile would be probably reasonable. Okay, generally speaking, in Manhattan, it might be, a quarter of a mile might be reasonable. All right. Yeah, who knows? 300 yards. Okay. So it really depends on the location. Every state, every city, every county, every judge is different. And, as I said, it's unlikely to be litigated in the first place or interpreted by the courts at all. But I'm just saying the reasonableness of a location restriction depends on where the business is located. The more urban, the denser the population, the smaller the area of the restriction needs to be reasonable. That's it on that. The next thing is time restrictions. Got to have a time restriction. It can't be unlimited. So same thing. Pretty much the more specialized a profession, the higher the skill level necessary, the greater the time restriction that will be permitted. So I generally try to get down to 6 months to a year as a reasonable area for employees. Generally, the employee will want a broader restriction. So I represent both employees and employers. And obviously, I work to either limit or expand the scope of the non-compete for each client. And obviously, the employer will want a year to 2 years, maybe 3 years, whatever. So anything above 2 years, you're getting into the unreasonable stage. I mean, that's a little excessive. I think 1 year should be okay for everybody, generally speaking. Okay, if it's extremely specialized profession, and if it's okay with the employee, they're sure that they're gonna, if they don't keep working for this particular employer, then they'll move away somewhere and it won't affect them. Then that's fine. You can agree to a year or more, maybe a year and a half, 2 years, 3 years, whatever. But I would generally try to work that time frame down as much as possible. So, but again, unlikely to be enforced at all. So not really anything to worry about. Last item that you will probably not see, which is done by larger institutions for high salaried employees, is a liquidated damages provision. Okay, so this is unusual, generally speaking. So it only says that if you violate the non-compete and they find out about it, then you are liable for either a fixed amount of damages, let's say 10, 20, 50, 100K, 75K, whatever, or you're liable for a percentage of your former salary, 10, 25, 30% of your salary for a year, whatever, you owe that money. Now, these are pretty dangerous. You got to be very careful because these are drafted very carefully. They're very strong, very restrictive, and the institution has the money to enforce these. So if you sign one of these, then chances are good that they're going to find out about it, and chances are good that they're going to sue you on it. So once they sue, you have to answer, you have to respond, because if you don't, then they'll get a default judgment, and they can garnish your wages, they can go after your personal assets. It's just a judgment. So they're going to have everything they ask for, legal fees and the contractual damages. So you have to answer, you have to counterclaim, and usually, if you fight them on it, then there'll be a settlement, and generally speaking, it'll be reformed, or it'll be canceled, it'll be terminated. Maybe the damages will be reduced. You can settle on smaller damages. It really depends on the individual case, okay? But you really have to be careful when signing these liquidated damages. I will rarely agree to liquidated damages at all, period, unless the employee really is okay with it. They're sure they're not going to violate the non-compete afterwards. They're certain about it, or they can pay it. So pretty much try to lower the damages, try to lower the terms of the non-compete, the location, the scope, everything about it. Just try to reduce it, maybe 3 months, maybe get it down to 6 months, maybe get the location down from 3 miles to 1 mile. Do everything possible to reduce the scope of that non-compete so that it's unlikely to ever be enforced. And so it's really something to be careful with the liquidated damages, because it can come back to bite you. So generally, lower paying professions will not have that clause in there, because it just costs too much money to go ahead and try to enforce it. Okay, so I think that is about it. Everything I want to cover, we've talked about. And of course, let me know if you have any questions, any ideas for future videos. Thank you for watching. Again, Lincoln Lawyer, subscribe, like, be cool, and stay the fuck out of court. Peace out.